Hello, good afternoon, everybody. And this is Tiny Man, and he is probably 7 or 8 years old. He looks like a Yorkie Chihuahua something mix, about 7 pounds, super long legs, came in very skinny, very shy, excuse me. And in about 5 days, realized that he really liked being in my office, and he's been hanging out here for about 3 weeks. And we're really hoping we can find him a great home, a quiet home with lots of nice warm laps for him to sit in. And he walks well on a leash once he gets to know you, but really sweet little dog. Came in as a stray, no owners found, and just a really great little dog. You know, we get a lot of these dogs that we find that, that come in as strays. We excuse me, we help the city of Oakland by taking in some of the strays. We have the contract with San Leandro, of course, and Livermore. We also take dogs and cats from municipal shelters, owner surrenders, and returns. So this little guy came in as a stray, and I think at some point probably had a family, maybe his person died or whatever, but super, super sweet little guy. And we're hoping that this week will be his week, it's his first week up for adoption, that week will be his week and he'll get into a really great home.
Well, thank you for that. So we're coming up on 12:01, and I know some people are still logging in, but I think we're going to go ahead and get started because we don't want to waste anyone's time this afternoon. So welcome. My name is Julie Henderson. I am the Vice President of Philanthropy here at East Bay SPCA. We very much appreciate your time in joining us today to get you some information about estate planning. I'm going to kick it off by introducing our President and CEO, Allison Lindquist, just to give a brief hello and to give a little State of the Union.
Hello, everybody, and thank you for joining us today. And thank you very much, Daniela, for your expertise that you're going to share with us. We are very, very grateful to our donors, and especially folks that consider us in their estate planning. The funding that we get in from estates is so critical to funding our vital work. We use this money to help subsidize our affordable, accessible vet care that's open to the general public. We have a full service clinic here in Oakland. We are one of the few animal shelters that has a full service clinic open to the general public. We also use it to fund training classes. As we all have been reading in the news, animal shelters are absolutely swamped, especially with dogs coming in. And a lot of the reason for this is people who can't manage the behavioral challenges of their pets. And so it helps subsidize our behavior and training programs, where we really work to keep pets with their people in the home. We don't want people turning their pets into the shelter. So, considering us in your estate planning is wonderful. And we are so incredibly grateful for the generous gifts that we get through this program every year. It really does help us do the life-saving work that we do. So thank you, and thank you for your time today.
Thank you, Allison. Once again, for those of you who just joined, my name is Julie Henderson. I am the Vice President of Philanthropy here at East Bay SPCA. We are incredibly honored to welcome you today. If you ever have any questions about anything East Bay SPCA related, or gifts or estate planning, please feel free to reach out to me directly. My contact information will be available after this, as well as the video recording of this session. Just a few housekeeping things as we get started. We ask that you please keep yourself muted until at least the end of the presentation, and we would ask that any questions that you have get put in the chat throughout the presentation so we can get the flow through, and then we will do a Q&A after the presentation. And now it is my honor to introduce estate planning attorney Daniela Lunga. She has been graciously offered to partner with us. She's done it in the past, and she's nice enough to do it today. To help you guys understand a little bit more about estate planning. Her expertise is very much appreciated by us, and we have full trust in her. So thank you for being here, Daniela, and I'm going to go ahead and pass it over to you.
Perfect. Thank you guys so much. Thank you all so much for choosing to spend a few hours of your day with me today about talking about my favorite topic, which is estate planning. And particularly today, our focus is going to be how we're going to incorporate pet trust planning in the general context of estate planning. So basically, the goal today is to talk about how to protect people, purses, and pets, right? That's kind of the general rubric of what we're going to be doing. So The format's going to be about 45 minutes of me talking. And again, please, if you do have questions, slide it into the chat and we'll get to those at the end, and everything that we don't get to, I will give you a way to contact me so you can reach out if you have additional questions. So let's just go ahead and dive in. There's a lot of material. You can't really talk about pet planning in general unless you talk about the rest of it, right? Pet planning is usually a component of estate planning in general, so you have to talk about the whole thing. But before we dive in, let's talk the general rules stuff, which is the legal disclaimers. I get this a lot. Are you a lawyer? Yes, I'm a lawyer. I'm not offering you legal advice. I'm just offering education about a topic that I really love, which is estate planning. So please take from it. I hope you take a lot of it actually today. I hope you learn a lot. Certainly, but if you have any individual questions about your own planning, please reach out and get a lawyer on board for that. So some goals for today. When I talk about estate planning in general, what is it? Like, why do we care? What are the documents? How do they kind of work together? Do I really need a will and a trust? What's a power of attorney? What's an advance directive? What do I need to make sure that I'm protected? What I need to have to make sure somebody else protected? Let's say I have an aging parent that lives with me, or I have a college-age kid. Like, what do I need to do to help somebody else? Those are basically the questions that we're going to get through today. Some of the things that come up in my practice, when people come in to see me, there's kind of a general theme, if you will, to the questions that are asked. One is, am I unprepared? Or conversely, am I prepared? Do I have the right documents in place if I get sick? What happens to me? What do I need to have, again, if I have an aging parent? What do I need to have for them to make sure that I can take care of them without any complications? What happens to my things? What happens to my stuff? Like, how do I get everything from my garage to somebody else's garage? Or what happens to my fur babies? What do I do with them if something happens to me unexpectedly? Like, what's that process look like? How's my family going to stay protected? So those are basically the common questions. Some of those might actually apply to you, but some of the common questions for most of my clients. So to begin, when you are looking for an estate plan, if you walk into any lawyer's office and you say, I want an estate plan, these are the 4 general documents that should exist. There could be more in your individual plan because planning is supposed to be unique, right? But the 4 basic documents should be this, which is the pour-over will, the revocable or living trust, the advanced healthcare directive, and the durable power of attorney for property. So if you go into any lawyer's office, those should be the 4 anchoring documents inside your plan. So just to begin, I'm only licensed in California. I only took the quiz here. So I don't know what other states do. So when I talk about estate planning, I'm only talking about estate planning as it kind of relates to California law and how to execute these documents and make them valid. If you do happen to move out of state, you might want to talk to an attorney in that state to figure out what documents they need or how those documents change for that particular jurisdiction. So let's dive into the first California state specific form, which is the durable power of attorney for property. It's a general document that says, I grant to my agent, which is the person that I trust, the ability to manage all of my finances if I can. If something happens to me and I can't. So the agent is not like super secret agent man. They don't have to wear a cape, but it's the person that you trust to actually manage your checking account or get access to any kind of a separate property. So for example, if you're married, you don't have automatic rights to your spouse's separate property assets. And I'm not talking about separate property in the context of divorces. I'm not talking about community versus separate property. That's a legal distinction. I'm talking about how you own something. So let's say, like myself, you get married later in life and you already have an entire financial picture, right? So you have checking and savings and, money market and all sorts of accounts that are in your individual name, but you're married now. And maybe you thought about maybe adding them at some point, but you just never did. And then something happens, right? In order for your spouse to get access to all those separate property assets, to do things like continue to pay bills or get money for continued care or whatever the case may be, whatever the need is, you have to have the legal right to do that. You can't just walk into a bank and say, well, my spouse is sick, I need to get access to this checking account because we have bills to pay, or there's medical expenses or whatever the case may be. You need a legal document, and that's what this legal document is. So it allows you as a spouse to get access to somebody else's or your spouse's separate property assets, insurance, retirement, separate bank accounts, that kind of thing. This document avoids what's called conservatorship of the estate, which is a component of probate court and also very expensive and very time consuming. Generally speaking, there's two general kinds of durable power of attorney for property. There's all sorts of other kinds of power of attorney, like, you know, real estate ones and special ones for specific types of transactions. That's not what I'm talking about. I'm talking about the durable power of attorney, which is a general, very broad power of attorney. It confers a lot of power to that person. And there are two kinds typically. There's immediate or springing. So I'm going to explain what that is. Immediate means as soon as I sign the document and I notarize it and I grant immediate power to my spouse, for example, then they can immediately take care of whatever needs to be done if something happens to me, right? I'm assuming that they're close enough to me that they're going to know when I need help. So let's say I have an accident or I'm in a facility or I've had surgery or I have a stroke or something and I just really can't manage my finances for a period of time. They can quickly run over to the bank, get their name put on the account to be able to start paying bills and things like that on my behalf, right? Springing means before that person, whoever I designate as an agent, gets the power to go over to the bank and say, hey, put my name on the account. First, they have to comply with the terms of the power of attorney. That may mean that either a one physician certificate or two physician certificates of my incapacity needs to be attached to that document before a bank will take it. Does that make sense? So springing means first, before they get to do something, they have to do something, right? They can't get the power until they do something. Immediate just means it's right then, as soon as it's signed. Now, typically, the power of attorney, they don't expire by law, but it's been my experience that most banks won't take them if they're older than 5 years old. So think about that for a moment. If you have an older plan or your parent has an older plan that was done 10, 15, 20 years ago, and they have an old power of attorney that they maybe haven't looked at, and maybe now they're starting to get older, like we all do, and maybe it looks like there might be some need to handle their finances, that might be one of the first things you should go back to their attorney and have redone, right? You want a fresh document with a fresh notarization. So that's the first state-specific form, the durable power of attorney for property. The next state-specific form is the Advanced Healthcare Directive. This is one where, again, we're talking about agency, which is the person that you designate that you trust to do the thing, right? And you are giving that agent the ability to manage your medical care if you can't. So what does that mean? So that might be the end of life decision making. So artificial nutrition, artificial hydration, life support meds. If you can't make those decisions, somebody does that for you. And that avoids what's called conservatorship of the person, which is a component of probate court as well. Usually the agent manages your disposition. So in the Advanced Healthcare Directive, there might be directions for cremation versus burial, or if you have a pre-need funeral plan, which I totally recommend everybody do, you want to make sure that you have that in place, and then you can write it on the Advanced Healthcare Directive, and then that person actually manages that call, right? They call the agency to handle whatever that disposition looks like, if you want to be buried or cremated or spread out at sea or out of an airport. I don't know what people do nowadays. They have those green mushroom burials or whatever. I don't know. Whatever it is. Look, it's hard to have that conversation. I get it. Maybe you're not like my family who, you know, they got to listen to me and everything that I wanted to do every Thanksgiving because everybody's around. So you don't have to do that. It's hard to have the conversation about, you know, the end of life, and everybody passes. So I would encourage you to try to have the conversation if you can gently. There's a website called prepareforyourcare.org, which I think has a lot of really great resources. When I send the intake packet for my clients, I send an American Bar Association form that is an advanced healthcare worksheet, which is also a really great way of being able to do that. If you have Kaiser has a really great internal advanced healthcare directive form and process that you can download, and then you can upload the form directly to the kp.org portal so that you can actually have that directly in your medical file, so you don't have to worry about scanning it and sending it over to them when it's complete. There's all sorts of ways to be able to do it, but just start with that conversation. One thing I want to highlight really quickly before we move on from this topic is the Advanced Healthcare Directive is not the same thing as the POLST form, the Physician Order of Life Sustaining Treatment form. There's been a lot of change. So the Advanced Directive used to be the living will and the power of attorney for healthcare. That changed years ago. The DND, the Do Not Resuscitate DNR, order has now been refreshed, and now it's this pulsed form, which is usually a form that your physician might offer you or one of your loved ones. If you're kind of end of life, a little bit closer, a certain period, if you will, you have a terminal condition or something like that. A lot of people that are of advanced age may not necessarily want heroic life-saving treatments like using the AED or compression and that kind of things that might actually result in additional damage or additional harm to the patient. So they use these pulse forms to be able to communicate that to their physician team and be a little bit more in control over what that directive looks like. So that's not what the Advanced Healthcare Directive is. The Advanced Healthcare Directive often goes hand in hand with the pulse form. That is something that is talked about with your physician, and it stays in your physician file. So I just wanted to clear that up. That came up in a class recently. So that is the second. We've talked about two really important documents now: the power of attorney for property and the Advanced Healthcare Directive for your medical care. The next document we're going to dive in and talk about, if this thing works for me. There you go. It's the will. Let's talk about the will, because this is when we're starting to dive into this meat of the crux, you will, of estate planning and the more important components of it, right? The will, and it doesn't really matter what kind of will we're talking about. It could be simple or holographic or complex or testamentary or pour over. There's all sorts of different types of wills in California, and all of them, in order to be valid, have to have certain components. They have to have certain what's called elements for them to be valid, right? So for example, if you Google simple will in California and you pop this up, that will form will actually have these components. One, it has to have an age or declaration or capacity declaration. Here in California, you have to be over the age of 18 in order to draft the will. So you have to be over the age of 18, and there's a statement that doesn't say I'm 18, but there's a capacity declaration. The second component is you have to understand who your stuff is supposed to go to. So you have what's called legal beneficiaries. And in California, that is what's called the intestacy code, which is the code that says who you're related to if you fail to say. So if you have a spouse, they're a legal beneficiary. If you have children, they're legal beneficiaries. If you don't have those, then you have other legal beneficiaries. But those two primarily are the ones that we want to make sure. If you do have them and you don't list them, then they're considered forgotten. So later they can include themselves in the probate process. So the court just wants to understand legally that you understand that if you have them, that something had to be done about them, right? So there has to be a provision in there that says, you know, I'm married to Jim Smith and I no longer want Jim Smith to inherit from my estate, or whatever that looks like for you. The beneficiaries are listed. That's who you want to take from your estate. The executor is the person that wears the hat to manage the probate process for you. And there we go. Gifts. Here, in some wills, you can specify gifts. So monetary gifts, for example, like the East Bay SPCA, I give them $50,000 for all their charitable, gift requirements or whatever. You could do a pet gift inside the will. You can gift your bike to your next door neighbor. The pour over will is a special type of will that names a trust as a beneficiary. We'll talk about that in detail a little bit later when we start to dive into why the will and trust is necessary. Now, what some of you might not know is all wills, again, regardless of what kind, whether it's the pour over will or testamentary or complex or holographic or all of those things, have to go through probate. A will by itself, the four corners of the will, is not valid until a court looks at it and goes, yep, we have all these components, so check the box of all these things. We have an executor that wants to. We have, the person had testamentary capacity to be able to do it. They actually listed the right people in there, right? Or specifically disinherited them or whatever. Nothing's automatic in a will, right? Also in California, which is different from other jurisdictions, a will, in order for it to be to give it that legal thing, in order for it to be executed properly, there's certain guidelines, formalities that have to be followed. For our jurisdiction, your will has to be witnessed by two people. So what that means is, if this is my will, then it doesn't become valid until I sign it in front of two people that watch me sign it, right? Then they sign it saying, yep, I watched Daniela sign her will. She indicated that that's what it is. They don't have to actually read it. So they don't care about what it contains, but they have to watch you sign it. Then they sign it to indicate that they watched you do it. And then there's a paragraph called an attestation paragraph that basically says, I watched Daniela sign her will and she didn't appear to be unduly influenced to do so, right? Nobody's standing over her with a bat or something, forcing her to do it, correct? That's really what that means. And then those two people sign it, they put their information, and that becomes part of the legal document that's submitted to court. And the court says, oh yeah, all of these components were done, check, 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 check. And then that's the beginning of the probate process, right? Okay, let's really quickly dive into some trust definitions, and then we're going to dive more into the meat of all of this stuff and how it all works together. So trust, interestingly enough, is kind of like a contract. And it says everything that I hold in trust, or everything that I title or fund to trust, is going to be for me to do whatever I'm going to do, right? I'm the trustee first, and I'm also the beneficiary during my lifetime. And then there's provisions or language in there that says what happens to your stuff after. So if you become incapacitated, once you die, who gets it, how they're going to get it, et cetera, right? The trick is those assets have to be funded or titled to trust, right? Which we'll talk about in a little bit. One of the beautiful things about having a trust is it avoids probate court. So if a will is an invitation to probate court, a trust avoids it if it's properly funded. We can also use trust to avoid or minimize estate taxes. Right now, most of us don't have to worry about estate taxes unless we own more than almost 14 million per person. As far as I know, most of us don't have that. I certainly don't, because I don't win the lotto because I don't play it. But you know, certainly we can add a component that actually protects against estate taxes in your trust, which is regularly done. So let's dive into this stuff, which is some definitions about wills and the revocable or living trust. Revocable just basically means you can make as many changes as you want to until date of death. So a will is a set of instructions that takes effect after you pass. It's amendable, meaning you can make as many changes or revoke it as many times as you want to while you have capacity to do that. The trust, on the other hand, is a set of instructions that's now. It actually talks about the things that I own now and how I'm going to manage it now, right? I'm the trustee. I'm the current beneficiary. It's a more present document. So that's the distinction between the two. So some similarities for both. I'm just going to put this entire slide up there. Both actually ultimately take care of distributing your stuff after you pass. So you're allowed to do whatever you want while you're alive, right? You can gift, you can, you know, charitable contributions on a yearly basis if you need to do that or you want to do that, you can absolutely do that. There's a component in both of those where you can actually indicate your charitable wishes in both your will and your trust, right? Your trust also has a gift component. You can do whatever you want with your stuff while you're alive. But ultimately, there's language in there about what happens to what's called the residual or the residuary, about what happens to your things after you pass. Both have no adverse lifetime income tax consequences. That just means that if I do, in fact, inherit from Uncle Bill, for example, and I get his $20 million estate, that first check that comes to me, I don't have to pay income or right now inheritance taxes in California. And then maybe at some point, if I take it and I invest it in commercial real property or whatever, then I might be paying income tax later. Some key differences, I think, wills, again, have to go through probate court. Again, they don't have legal muscle. They don't have oomph until a court says, yep, it was done right. We had talked about all those components, right? The age declaration, the named executor, they want to, it was witnessed properly, it was executed properly, nobody had capacity issues, right? Probates are public. So when a probate petition is filed, there's a document that goes to court and it says, this is who passed, this is their beneficiary. So it lists names and addresses of everybody that you're related to that's going to inherit from your estate. So kids, et cetera, whether they're minors or not, it doesn't really matter. Who is getting it, where they live, what is going to be included. So names of beneficiaries, again, the addresses of all the homes that you might own, the bank accounts and all of the amounts that are in those bank accounts, all the assets and the valuation thereof goes into a public document that's accessible to anybody with a computer. And they don't have to have any connection to you at all. It's just anybody that has a computer can download those probate petitions, which is a little scary, right? It's probates are very public. They're only good in the state of residence, and again, only effective at death. One of the benefits might be that it does not require funding, which we'll talk about very shortly. Trust, on the other hand, effective right now. Again, we talked about it. It's a present thing. I am the trustee of my trust right now. It talks about what happens to my stuff right now. It talks about what happens to my stuff if I become incapacitated. One of the beautiful things of it is it avoids probate. It's a private document. You don't have to share it with anybody if you don't want to. In fact, I regularly tell my clients, do not. Just tell your successor trustee how to find it in your home if something happens to you. So again, they're private. They're good in every state. I talk about trust kind of a little bit like a picnic basket. What is a picnic basket? It's a bowl, right, that you can put your snacks into. It has a handle and you can take your handle everywhere. So let's talk about portability for a quick moment, because I have a couple of minutes to do that. So let's talk about the person that lives in California. They create a trust-based plan, right? And they take one of my classes and they decide, I don't want to be bothered to do a trust. I'm just going to do a will. It's easy. I can do one online really quickly, and it's fun, right? But that person owns a house. They own a house somewhere in the Bay Area. And then they move to Colorado and they buy another condo, right? And then they realize that the snow is not for them. So they retire to Boca, right? Where maybe the weather is a little bit more favorable. And they live in Boca and it's warm there, and they buy another condo. But they have now 3 homes, right? You follow me? They have the California property in the Bay Area. They have the Colorado property. And now they have the condo in Florida. They live out their life. They're old and happy, and they pass away gently in their sleep, and it's totally fine, right? So what do they have? They have a California will that they never updated. They never redid it in Colorado or in Florida, and now they've passed in Florida. So what happens? Well, legally, you've saddled your family with 3 probates. The first probate is the jurisdiction where you live. So they have to start in Florida. They have to do an ancillary probate or extra probate everywhere else where you have property that doesn't pass to somebody else. So in our example, we have the Colorado property and we have the California property, right? So we have to do ancillary probates in those 2 other jurisdictions. When the court decides if the will was valid, right, was it done right, they're not going to look to Florida law because the will was drafted in California. So they have to go back to California court and say, hey, was this will properly done? So, think about those components that I talked about earlier, right? Witnessing, et cetera. So that's one way of doing it. That's one way of handling your estate. Maybe easy for you, maybe a lot more difficult for your family later, right? Alternatively, you could do the same exact scenario, same exact assets. You have a trust. Again, back to that picnic example. So you take the California real property, you put it into your trust picnic basket. Then you move to Colorado and you title that property to your picnic basket. Then you do the same thing with your Florida property, put it in your picnic basket. You pass, your successor trustee gets to title themselves to all of those assets that are in your picnic basket, right? That's called funding. And all they do is a trust administration, which right now, probate is really expensive and long, but that's one way of being able to avoid all of that. But it requires funding, right? So you as an individual gets to decide where do you kind of see yourself landing? Do you see yourself at making it really easy for yourself, and then making it easier for your family later? Easy for yourself and then making it harder for your family later? It's really up to you to decide what kind of planning makes sense. But let me show you, hopefully visually, what funding means, because I get that question all the time. What is funding? You talk about funding multiple times in your class. What does it actually mean? Why do you care? So let's talk about myself. So when I created my estate plan, initially, I had the 4 documents we talked about, right? The will, the trust, the power of attorney, the advance directive. Now, with a trust, that trust estate, my goal is to make sure that it's properly funded, which just means, how am I going to title or own assets to that trust? So what does that look like? It may be that your personal property, we do an assignment of personal property, which just basically takes your bits and baubles, furnishings and the contents of your home and maybe your car and that kind of stuff. And it titles it to the trust by operation of law, right? Then we take real property. So any house or land that I own anywhere in the United States, I can title to my trust. So it doesn't matter if I'm a California resident or live in New York or whatever, you can still take it and title it to it. So all of my homes are titled to Daniela as the trustee of Daniela's trust, okay? All cash accounts also are titled to that trust. So my checking, savings, money market, security accounts, investment accounts, brokerage accounts, my E-Trade account, everything is titled to Daniela as the trustee of her trust, right? So that's how it's nice and protected inside that picnic basket. Then the insurance policy. I like insurance policies to name as the trust as the primary pay on death beneficiary. I want to make sure there's an influx of cash when I die so that they can pay whatever distributions, whatever gift. I mean, I in my plan, I do have charitable contributions that I'm planning on making to charities, right? So for example, the East Bay SPCA, I want to make sure they get that fast. So I want to make sure that there's enough cash to be able to satisfy those gifts quickly in the context of administration. The only one that's a little bit different is retirement accounts. I only want the retirement to name the trust as the last contingent beneficiary. So typically it would be your spouse is your primary beneficiary, your children, if you have them, are contingent beneficiaries, and then your trust, if they allow it, might be the last or alternate contingent beneficiary. So here, if I die right here, you can see that I have a fully funded trust estate, meaning all of my stuff, all of my bits and bobbles and goodies are inside my trust picnic basket, which is exactly where I want them to be protected, right? But sometimes things aren't always that easy or that that self-explanatory, if you will. So I'm going to give you an example of the thing that happens most often for my clients, which is the refinance of the house. And let's say your lender requires that you take the house out of the picnic basket. So instead of being titled to Daniela as the trustee of her trust, it gets retitled back to Daniela as an individual for purposes of that refinance, which is usually about 30 or 45 days, right? Everybody with me? Okay. Now, it's your responsibility as a homeowner and as the trustee to make sure that house makes it back into the trust, right? It used to be that title companies would do what's called correcting or courtesy deeds to put it back in the trust. And sometimes they don't do that anymore. And sometimes they don't tell you that they don't do that anymore. So it's kind of incumbent on you to make sure that your property is titled to your trust properly. But let's say that didn't happen. Let's say in my example, I refinanced and I forgot, right? And then I passed and it's titled to me as an individual. That property, no matter what, has to go to probate court. There's no other legal way of getting it to anybody else. And remember at the beginning, I told you there's a pour over will that's fancy and we'll talk about it later. Well, this is the later. A pour over will names the trust as a beneficiary. And the only purpose is to connect probate administration to trust administration if I make a mistake. So that fancy pour over will that names Daniela's trust as a beneficiary gets sent to court. So there's still a probate petition. Somebody's still going to find out who I am. They're going to find out all my stuff, right? That didn't land in the trust. It wasn't properly titled. My house primarily, right? And the whole probate process has to be concluded, right? The pour over will just allows us connection, and it allows the judge to issue an order at the end to pour this asset, like a pitcher of water. It takes this house and it pours it back into my trust estate so that, again, if I have charitable bequests, I have random individuals that they, like for me, I don't have natural beneficiary children. I don't have any children. So I have fur kids. I have a couple of those. I have a spouse. I have charities that I want as beneficiaries. I have individual friends that I want as beneficiaries. So all of those, in order to make sure that they get my stuff, I want a connection just in case I make a mistake, right? I'm not going to rely on my memory all the time, right? So that's what the pour over will is there for. So when somebody says, well, why do I need a will and a trust? Well, that's why. There's just a fancy kind of will just to connect that probate process if you make a mistake, right? So the will is just a backup if you make a mistake. So let's briefly talk about probate, which is the default. Did you know that that's the default for everybody? So everybody has an estate plan in place, whether you like it or not, and it's called probate. That's the bottom line. And actually the default for everybody is called intestacy probate, meaning that you never even wrote anything. The basic probate starts with a will. Again, a will is not a self-executing document. First, a court has to say, does it meet all these checkbox requirements? Then that whole thing happens, right? So probate is this legal process that says, hey, somebody passed. What happens to their stuff? I'm not talking about stuff that has a legal way of getting to somebody else. Like say, for example, you have a retirement account, 401k, IRA, Roth, annuity, et cetera, and those have beneficiaries. If your beneficiary outlives you, then that avoids probate. That's fine. You can have a beneficiary on a retirement account. That's fine. Also, if you have a beneficiary on a life insurance policy, they also get it. That's fine. You can also sometimes do pay on death or transfer on death beneficiaries to bank accounts. Some accounts let you do that. So those are ways of avoiding probate. I'm talking about when you don't have that, a legal way of getting to somebody else. So again, a probate process is this whole thing that says somebody died, either they did this will or didn't do the will, they have stuff, what happens to it? It's this entire thing. Nothing gets distributed to the end, usually. And let's talk about the price of probate. It is the date of death value of the thing times a certain percentage, right? So if you have a $500,000 house, for example, the probate fee is $26,000 paid to the executor and to the lawyer, right? Down at the bottom where it says fee is $0 if asset is entrusted, it doesn't mean that there's no trust administration fees, but there's no probate fees, right? Because we're not going to be doing probate first unless you make a mistake, right? So it's expensive. It's really expensive to do a trust. And right now, or to do a trust, to do a probate. Right now, Alameda, Contra Costa, Solano, San Joaquin, Santa Clara, almost all of the 9 county Bay areas, they're running about 2 years point to point on a probate. So 2 years before somebody can inherit, 2 years before they get the bank account, 2 years, and if there is a house and they can't sell it in the context of the probate, that they have to pay the mortgage, otherwise the lender will take it, right? So it's really, really expensive to do that. There's a lot of reasons why people avoid getting an estate plan. They think it's too expensive, or, you know, I get this a lot. Well, I don't own my house. The mortgage company owns the house. Well, but yeah, but you know, we don't factor in any debt when we're calculating probate costs. It's the date of death value of the thing without any offset for debt. So think about how expensive your estate is, right? If you think about the net versus the gross estate, if you're going to, you know, quickly jot that down. Or they're superstitious. I mean, there's all sorts of reasons. But again, if you don't do anything, there's always a default, right? So don't worry about it. If you don't want to take the time to protect yourself and your family, you don't have to. There's always a plan in place, right? Guardianship, conservatorship issues, the court controls your assets. You could have minor kids where the court just determines guardianship versus having any input from you. That intestacy for all of your assets can be distributed according to law instead of what you want. If, of course, you have a much larger estate, you lose it to that. And then the component that I know a lot of you are here to talk about is pets. What happens if you don't take care of your pets in the context of your planning? Well, you can actually have a pet that goes to somebody that you never wanted to inherit your pet, right? Or what happens a lot is your pet ends up going to a shelter because nobody in the family wanted them. And it's easier for them to take them and drop them off and not worry about it, maybe, you know, which happens a lot, unfortunately. So who needs a trust? I think everybody does. I think especially if you own real property anywhere in the United States, you want to make sure you do a trust-based plan. If you own more than $208,000 worth of stuff, you want to do a trust-based plan. That 208 is the number for getting into basic probate. Not that there's not other things that cost a lot of money as well, but that's the basic amount for getting into full-grown probate. If you want to spare your beneficiaries the burden and the cost of probate, definitely. If you have pets and you want to do pet planning, please consider doing a pet trust. It's a lot more expedient than doing just will-based planning. If you have specific distribution desires, again, pets, I can't mention that enough. If you're doing a pet planning, please make sure you think about doing a trust. And then, of course, if you have a much larger estate, you want to do that. Some mistakes that I've seen in planning, not having sufficient life insurance. We use life insurance for a lot, including satisfying pet gifts or any type of charitable bequests. We use those life insurance proceeds to make it really easy so nobody feels like they're getting shorted. Not creating a pour over will at the same time as the trust, not fully funding all assets except for retirement accounts. Those are exceptions. Choosing an out-of-state trustee, which I wouldn't consider doing. Not incorporating your digital assets or not amending documents as changes happen. Think about births or deaths or divorces or something like that. You want to make sure you amend those documents fairly quickly when big life events happen. Not considering family dynamics before choosing a trustee. Please do not pick your children by order of birth. Please talk to your lawyer about what the job entails and pick the right kid after you know what that means, right? Splitting assets that are not divisible. So that's really if you have unmarried people that purchase a home that's not divisible. It's not a duplex, one home together. Adding kids to bank accounts, please talk to your lawyer before you actually do that. So let's dive into pet trust planning. I love pet trust planning. I do. I started doing it years ago. I will show you a picture of the catalyst for why I started doing pet trust planning. But there's basically 2 large categories of pet trust planning or handling things for your pet. There is the gift with pet. And when I talk about pet trust planning, I'm talking about it in my preferred method, which is through the trust, because I think it's so much easier for those gifts to be satisfied, and actually the short time frame for being able to handle your pet. You don't want your pet to go to a shelter in the interim or have nobody that's able to take care of them financially or otherwise because they're waiting for a probate to be concluded, right? So I'm talking about in the actual trust itself, what happens with that. So a gift with pet, simply, $10,000 and my dog Fluffy to my friend Sally, right? If you're doing a specific type of gift, like a pet survivorship or pet guardianship program, like the one from the East Bay SPCA, then that is a provision that we would put in there that says the whatever the monetary gift is, and then whatever the additional gift is, and my pet as part of the agreement of the pet survivor, pet guardianship program. And then maybe we refer that particular agreement and we put it at the back of the trust, right? So it's a really easy administrative process. So it would be considered a gift that's actually a provision in the gifting section of the trust, right? To be able to satisfy that quickly. The other way that you can handle your favorite pet planning is to do an actual pet trust, which is a set of money that is set aside that is managed by the successor trustee for a period of time. So let's say it's $50,000. Well, in fact, let's go to the next one. Look, so we talked about the gift, which is the Pet Survivor Placement Program for the East Bay SPCA. That would be a gift inside the gift section of the thing. Now, the trustee helps transfer that pet, right? So whatever paperwork needs to be signed, if you're transferring the chip, if you're transferring ownership, that kind of thing, the physical movement of the dog or cat from the decedent's home to the SPCA, right? And then the check, the successor trustee has access to the bank account, would take the check and would hand it over. Here's the $50,000 and the care of my pet, as also further explained in the process, right? The next one is the pet trust. So same 50,000 that we're talking about, but this is an amount of money that goes into a pet trust. It's a separate bank account. So the successor trustee will take the money, go to Chase, for example, open a pet trust bank account, and that money gets doled out on a monthly basis to whoever has the care of the pet until either the pet passes, right, or the money is depleted, right? I had a very expensive pet, so that wouldn't have gone really much. But anyway, the trust actually stays open, right? The administration stays open until that last dollar is allocated, right? So there's a little bit of, if you will, supervision. The successor trustee gets to actually talk to the pet guardian on a regular basis and kind of has contact with them until that transaction is concluded and the trust stays open, okay? So some mistakes. What have I seen in the years that I've done this? Not having enough cash resources to care for your pets. And I know that you can't always envision what that might look like in the future. But if you have an exotic, like a tortoise or a bird or I don't know, horses live a really long time. If you have a pet, I would encourage you to figure out what that looks like, what that reasonable value looks like, and see if you have the resources. Again, life insurance, the resources to be able to do that. The second thing, kind of assuming that your family is going to take ownership of that pet without actually having conversations or agreements with them. Unfortunately, I've had a couple of situations where I've had clients that were very, very attached to their pets and their families were not so much. And so they made assumptions that their kids or their relatives would take them. And they did, unfortunately, straight to a shelter, which is not at all what they wanted. I know that. Not having a written component, please consider it, even if it's not some really big, huge formal thing. It doesn't have to be several pages or several documents worth of stuff, but just have the agreement with the person that's going to do the thing, right, to take care of your baby, and then also have a written component in your estate plan. Specifically, my recommendation would be put it in the trust where it's easier. So not considering the life expectancy of pets, especially those exotics like birds and tortoises. In fact, the other day there's a very famous woman that owns a tortoise out here in Concord, and I saw her walking her tortoise. I thought it was the most magical thing I've seen all day. She has a special stroller for the tortoise, but she was actually just walking down the street, and the tortoise is like do 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 do. You have to think about that. I mean, how long do they live? 120 years, 140 years? They can live a really, really long time. So you just want to make sure you have their life expectancy kind of factored into your planning. And make sure you have the planning in place before you get sick, before you actually need it. There's no time like the present. And the little dog in the corner, that's Kairu. That's actually the reason why I started doing planning to begin with. I don't know if you know white dogs and boxers, but they couldn't be more delicate, and she was probably one of the most delicate ones. She was a pure breed and had a lot of health issues, and she's the reason why I started getting into pet trust planning, because I saw how much effort it took to take care of her, and I wanted to make sure that, God, if anything happened to me, I had an easy transition so that she wasn't stressed out. She had a good place to live, and she had enough money to take care of her because she had a lot of medical needs, unfortunately. So I have totally different dogs now. I have two little rescues, but she's the reason why I did it. So let's talk about some real life examples. I had a client, a local resident, and they put $5 million into just a trust that the only beneficiary of the trust was their dog. And they had a charitable remainder for a local charity, which I think is fantastic. They did exactly what they wanted to do. They wanted to make sure their dog was taken care of. They had a pet guardian, and then the rest of the money went to their favorite charity. You can do whatever you want. I mean, that's the beauty about having trust-based planning. You can do whatever you want. You can write it in any way that makes the most sense for you and your loved ones, right? Leona Helmsley, the Queen of Mead, probably one of the first people that I ever heard that did a trust years ago for her Bichon Frise, a little boy named Trouble, put $12 million in a trust for him. Later, the kids that she had disinherited, they did what's called reformation. They went to court and said, you know what, this dog isn't big and it's not going to live forever. So they don't really need 12 million to take care of him. So they reformed it to 5, and they took the rest, which I'm sure she wasn't very happy with. I've had trusts that were done for pet birds, right? Really, really long trusts that are meant to last a really long time, because that parrot actually is going to live a really long time. So again, I've had many, many clients that have done plans for horses and dogs and cats. Within the context, you can do a general provision, a specific provision. But again, if you don't have any plan in place, there's one that exists for you, so don't worry. There's some really great resources, and there's a pet survivor placement program here. Julie is gonna in a few moments is gonna pop on to our Zoom and talk about that component of it, and certainly I think a really fantastic resource. If you are a California resident, you're allowed to come talk to me for free. You can take advantage of a complimentary consultation. We are going to share the slide deck, and so if you'd like to send me an email or call me to schedule that, I'm happy to do that. If you have a charitable question or a charitable component, or you have a pet that you need to have protected. And now, to prove that I am also coming into this century, if you learned something today, I would love to hear it. If you can whip out your phone and take a little snapshot of the QR code, I would love to hear your thoughts. And hopefully you learned something great about how to protect your family, what a will is, what a trust is, what a power of attorney is, those 4 documents we talked about, and how to protect all the loved ones in your life, all of your people and purses and pets. And with that, that is the conclusion of my talk, and I'd like to pass it over.
Thank you, Daniela. That was fantastic, very informative, very much appreciated. So as Daniela mentioned, we do have something we call our Pet Survivor Placement Program. My information is in the presentation. I'm also going to put my email address in the chat, but we're going to follow up with everybody that was here today with some documents, including this presentation, and a one-pager about our Pet Survivor Placement Program. I'm happy to work with you one-on-one to facilitate if this is something that you're interested in. And yes, we just want to make sure that our supporters feel that we're here to support them how we can. So we appreciate you coming today, but we did want to open it up for Q&A. We have Daniela here for the next like 10 or 15 minutes or so. So if anybody has any questions for the group, I'm sure other people are thinking of the question too, so don't feel embarrassed about asking anything. I would ask that you can either put it in the chat. If you go to the bottom of your screen here, you can see there's a chat function, or if you just want to raise your hand and ask it, you can unmute and do it that way. So we're here to take any questions. And I'm going to put my email address in the chat while we're waiting to see if anybody would like to answer any questions.
Well, I suppose I can do that as well, huh? Nobody has questions? Everybody's shy today?
Let's see here. We do have a question here in the chat from Jeffrey Thomas. In the absence of a specifically named person to take care of a pet, what are the other options? I can just answer, first of all, working with East Bay SPCA with a pet survivor placement program would be an option. Definitely there's programs like this out there, and we are here to help, especially our supporters. But Daniela, you might have some other options as well that I know you briefly touched on in the presentation.
Yeah. So other than these formal organizations, the default is going to be your family. It's who's in the room. And they scramble. I mean, my family clients that don't have specific direction, or where we struggle probably from an administrative standpoint is somebody passes and they have a pet and nobody had a conversation about it. So they're scrambling. Everybody's calling me like, what do I do with the cat? What do I do with the dog? And so we have to reach out to all the family members and we have to kind of insert ourselves into their shoes, which is really incredibly difficult. You can only imagine, right? So if you don't engage in a formal agreement, which is what I would recommend, like have a formal conversation with somebody in your family and have a backup. Like, my friend Sally, and if not my friend Sally, then my friend Bill is going to take my dog, and just make sure that they understand what that means, right? They have a relationship with your pet. They have the information to be able to take care of your pet. So that's
and I would just I would piggyback on that. We do at times have people come to us and they have been the executor of, let's say, their parents' estate, and their animals were not taken into consideration, and they inherited them, and they're in situations where maybe they have another animal in the home that this animal is not compatible with, and they find themselves in situations that are very difficult. So we try to help out when we can, but it really is important for your animals to ensure that you have a plan for them, to ensure that they're taken care of, because this does happen quite a bit. Let me see here. So Bonnie Carlson asked, will you send out a recording of this meeting? Yes, that is our plan. We plan on sending up follow-up materials. We are planning on having a recording of this in a follow-up email, but also we're going to have it on our website as a resource for anyone who would like to take a look and look at it. Let's see here. So Jeffrey, can a consideration for a pet be named in a trust, but without a specific person? In other words, would I have to name, for example, one of the programs like East Bay SPCA's program?
I think what Jeffrey is asking is, in lieu of naming Sally as somebody that's going to take my pet, can I just name the organization? And I believe you have to have an agreement with the organization before they'll take your pet. So you can't just randomly, Julie, is that right? You can't just randomly say, well, my pet's going to go, unless you have an agreement with them and you have, because there's an intake, right? They have to make sure that they know before they take your pet in what that might look like. I mean, do we have
it definitely to secure the placement, it definitely to have a predetermined partnership with a shelter like us or with another person. It does make perfect sense that you have to have a pre-existing agreement with them, because oftentimes like shelters have to plan for being able to take care of an animal, and there's also an agreement that has to happen about specifics for your animal. Often it's great to hear that animals are perfect and they get along with everybody and the shelter environment's not going to stress them out. But the reality of the situation is the shelter is a stressful environment for any animal, and also considering any kind of medical treatment that's needed for the animal, specifics on medication and all that type of stuff. It is really important for the well-being of the animal to make sure that you have that predetermined before you include it into a trust.
Right. You can't just rely, and it's sorry if I didn't understand the question to begin with. You can't just rely on the organization to just step in if you don't have that agreement, which is why I was suggesting that in the trust, you would say, my pets, and those have to be specifically named. So Fluffy to the East Bay SPCA, and it refers to the actual agreement. And then you take a copy of the agreement, put it behind. So the successor trustee would just call and say, okay, now it's time for the transfer. And then that process starts turning forward, if that makes sense.
And I did want to interject in my experience here in dealing with many pet survivorship program pets that come in, when they come to us, one of the first things that we do is really check them out medically. Frequently, a lot of these animals are older and have some medical challenges while the person was dealing with their own medical challenges at home. So we get our veterinarians involved or outside specialists and make sure that they are taken care of. We also work to get them out of the shelter as quickly as possible. This really is a way station for them. We want them to be back in the home very quickly. So we'll get them medically checked out, and then work with foster homes. We do have foster homes that sometimes will take these animals so we can keep them in a loving home environment. And then we'll work very carefully to get a specific adopter that is willing to take on the pet and its challenges. We have had pets that have come with an amount of money assigned to them, and we want to make sure that the person that is adopting, that we've got a relationship with them, and that that animal is going to get the care that they're supposed to get. And that person has, in one particular case I'm thinking of recently with an older dog, that person did stay in touch with us and let us know about the dog's well-being up until the time that the dog passed of natural causes.
Very cool. Thank you for that.
And staff sometimes ends up adopting these, I have to admit. We fall in love with these animals that come from these situations, and we have seen staff frequently take home these older, well-loved pets so we can just get them right out of the shelter.
Yeah, my office fosters always tend to be these pets when they first come to us, because I always have an extra special place in my heart for them. So,
Right.
So Allison asks, when is the best time to sign up for Pet Survivor program? You can sign up anytime. The documentation is going to be linked to our follow-up email, and feel free to reach out to me for consultation. What I typically do is we share the information, and there is an application that goes along with it, but I typically set up one-on-one meetings either in person or over the phone, and I'm here to answer any personalized questions I can for you. So anytime is a great time, but always sooner rather than later, because unfortunately we just never know what's coming next. So any additional questions?
Really quiet group today.
I just have one additional comment. Be sure that the paperwork for the intentions for your pet, that your family or executor knows where they are. We have had a situation at least once, actually a couple of times, where the pet goes to the city shelter where the person passed. And the good news is they did have the documentation. We were able to retrieve the pet from the other shelter and get it into our care, and get it taken care of.
We do have a question here from Janet. Do I have to name specific pets in the trust? Do I have to update the trust whenever I get or lose a pet? I'll let Daniela answer that from the trust perspective, but I will tell you for our program, we do an annual check-in, usually around June, with every member of our Pet Survivor Placement Program to get updated names and information on the pets that are enrolled in the program and just check in with you. And then we do also ask if you do have a pet that passes away, just to notify us and let us know. So we do our best to do at least an annual check-in with you to make sure on our end the records are up to date. But in terms of the trust, I'll let Daniela jump in.
Yeah, so you can have a general statement. Any pets that I have that are currently enrolled in the pet survivorship program with the East Bay SPCA, and then, please refer, like there's language in there that says, please refer to whatever. So that's a more general direction for the successor trustee. So they know that if you do happen to have pets, that you've also completed whatever the paperwork is, right? So you don't have to do that specifically. You can opt to add each individual pet as you have them if you want to be more specific. In order to amend your trust, though, you have to amend it as they pass and then do regular amendments, if you will, to actually freshen up that name. So it depends really very much on what you want to pay for. You can do a more general, more neutral language in there. It's a great question too.
Any additional questions? Okay, well, thank you so much for being here today. You have my information as well as Daniela's, but we're also going to be sending out via email, like we said, the presentation, We also are going to be sending out information about our specific pet survivor placement program and a recording of today's webinar. Thank you so much, Daniela. This was incredibly helpful. We really appreciate your support and expertise. It's really vital to ensure that our supporters have feel peace of mind, especially when they're talking about their pets.
Thank you. Thank you, everybody, for joining us today. Super appreciate it. Please remember that even if you're not doing a specific pet survivor program, that you do consider your charitable bequest to your favorite charity. Yes, you guys, you can still do that in lieu of. You don't have to do the pet survivor thing as well. So consider that.
Thanks so much. Everyone have a great day.
Bye, everybody.